you. Our final presenter for the panel is Roy Kaufman. He is Managing Director of Business Development at Copyright Clearance Center, and he will be speaking on the U.S. approach to AI extraction and text and data mining. Thank you, Roy, and welcome to the stage.
Thank you, Leah. So if you could put my first slide up, please, which is just the title slide. And I'm here talking about, not shockingly, copyright matters, given that I work for Copyright Clearance Center and am involved in these. And so just, trying to reduce complicated concepts, including really complicated concepts of US law, to 8 minutes. I'm gonna just have to skirt a bunch of things. What I'm talking about here, though, is sort of building, Carlo was talking about licensing. And what I want to talk about is use of copyrighted material for text and data mining or AI extraction in the absence of a license, right? How does US law approach it? Because I think there's a lot of misunderstanding about how US law regards this. And, so I'll go on from there, but, certainly licensed material, whether you have a license from the creator, an open license through open access or what have you, obviously the license is what's going to govern what you're doing. So if we can go to the next slide, I just also wanted to point out that to me, AI extraction, text and data mining are overlapping Venn diagrams, and it's certainly useful from a perspective of the law to sort of look at them together and analogize, because really there isn't a lot of law about AI extraction or making of copies for AI extraction. And there's not even a lot of law in the US about text and data mining. My view is when courts and legislatures get to these problems, the best case scenario is they solve yesterday's challenges tomorrow. They really, they're working on old facts. It takes them forever to get to a resolution. The facts have moved on. And so it's a little bit tricky, and I'll get to that in my next slide. But first of all, I want to talk about, back, sorry. I will get to that, but not yet. So I just want to talk about when I'm thinking about this, you have, tools and fuels. So software and input. So software, in my analogy, which I'm going to torture even further, that's the car. That's what takes the input and does whatever, the outcome is, whatever you want it to do. That software is protected by copyright typically, but I'm not talking about that. The input might be protected by copyright. And typically, if you're using copyright protected input, you're going to make additional copies of that to turn it into XML or to format it or tag it or enrich it in some way or another. And that's what implicates copyright. So copyright is only implicated if it's copyrightable. So if it's text and images, copyrightable. Fish, Todd, thank you for that. Not copyrightable. Fish are not copyrightable. Pure data is not copyrightable. There might be some legal controls over it through access or contract, but it's not a matter of copyright law. So really, copyright law becomes implicated when you change it to create the input to put it in the machine. But in the United States, we have this doctrine called fair use. And what I've heard in Europe a lot is, oh, well, text and data mining in the United States is fair use. That's like saying a car is fair use. A car isn't a use, it's a car. It takes you someplace. The use of the car is going to the hospital or going to work. And so when you're doing a fair use analysis under US law, you're going to want to look at the actual use, and you can't just say, oh, it's TDM or AI extraction and say that's the use. You have to say, what is the purpose of that TDM extraction? What is the purpose of the AI? So now let's go to the next slide. And because this is an international audience, I decided instead of using the fair use factors, I would actually look at the Byrne three-step test, because this applies everywhere. It underpins our fair use concepts in the US. And I just want to build on something that Carlo kind of hinted at. The second of the 3 steps, so this is, exceptions are lawful under international law if they follow these steps. And the second part of the 3-step test is that the reproduction does not conflict with the normal exploitation of the work. And as Carlo was saying, this is becoming normal. And this is why frankly, TDM and AI extraction and solving yesterday's problems tomorrow is so complicated and so hard, because what is the normal exploitation today might not be the normal exploitation tomorrow. Streaming was not normal exploitation of music for a very long time. It didn't mean you could have an exception for it because it might have violated some of the other three. You have to hit all three steps in the three-step test. But nonetheless, the world changes very quickly. And as the world changes, what's the normal exploitation will change. And particularly, you know, when you're looking at scientific content, scientific journal content, normal exploitation already includes text and data mining, XML, AI extraction. If you're looking at, and we'll get into the Google Books case in a second, if you're looking at old books on a shelf, that's probably not normal exploitation to mine that. So that's sort of how we get where we're going. So let's just sort of go on to the next slide, please, because I'm already down pretty short in time. So I just want to talk about three cases, and I'm using cases in air quotes, because actually only two of these are not all actual cases with decisions. So, you know, most people, when they're trying to figure out where does text and data mining, and then by extension, copying for AI extraction end up in US law, they'll look at the Google Books and HathiTrust case. And again, back to my example of text mining isn't a use, AI extraction isn't a use, it's what you're doing that for, that's the use. So in these cases, they were sort of looking at the making of copies of print books. These are, you know, things that are probably not in digital format prior to the copying. And the use was non-commercial semantic research. Now, these are very long decisions and they barely talk about this. So, you know, there's like a couple sentences about text and data mining. It was just sort of like an example thrown in, and a very specific example. When does, you know, United States, you know, go from, you know, when it becomes United States is as opposed to United States are. And that, you know, does feel like it's not exactly, you know, the primary use of that content. And, you know, again, so you're looking at the actual use, you know, stuff that wasn't created for text mining, wasn't created at a time there was a extraction, wasn't even created at a time for the most part where there was such thing as electronic use. And, you know, something that people don't know, I say the Google Journals case. Everyone's like, what's the Google Journals case? Well, when Google started the project of scanning all the books, they were also scanning all of the journals. And I was working at a journal publisher at the time, and yeah, draw whatever inference you want. In the middle of the lawsuit, the general counsel of Google wrote to the publishers and said, we're not going to scan journals anymore. Well, why weren't they scanning journals anymore? You know, they had good legal advice and maybe they just didn't want to, or maybe they realized that actually scanning journals, selling them to libraries and using them for these different purposes was actually a primary business of the publishers, or regular business of the publishers at the time. It was. And so they stopped scanning him. And, you know, as is one of the challenges, it'd be really great to know what they think about this type of scanning, but they don't, because it wasn't before the courts, because Google stopped the scanning. But again, you sort of have to look at everything in the facts. And the last case I'm going to talk about in my remaining over time is the TVI's case. Now, this is not text mining because it's not text, it was audiovisual content. But again, it was taking huge corpus of AV content and sort of reducing it to a new use. And people have to look at it because I'm over time. It was transformative. It was a transformative use, but you know, this was a later case. It was a more commercial use than certainly the semantic research in the Google case. And the Second Circuit, in this case, same court as the Google case, basically said, no, this is not fair use. This is, you need to get a license to use this material. So I'm just going to end there because, again, I'm pretty much finished with my time and hope that people have questions and move on from that.
Thank you very much, Roy, and thank you to all of our presenters for the panel. I'll invite you all to